Okay, so rather than sit here and just go back and forth on when things were filed and who can be ready for what, would it be more prudent to just have these heard tomorrow, even though we're all here?
I'm ready to, if the court wants to do the one today or all tomorrow, depends on the court's pleasure.
Okay, so we have three motions. We have the, I'll call it the Swastika motion, which I'm very familiar with. I assume both sides are familiar with that motion and the merits of it because it's been argued many times. And who's going to be the point person from the defense?
I will be on.
All right, are you ready to argue that motion?
Yes.
And state you're ready to argue D306?
Yes,
I'm sorry, not D306, excuse me. SF222 in response to D306.
correct.
Okay, is there anything that you'd like to add to your written motion?
No,
There's no argument?
oh, and yes, there's oral argument, yeah, I thought you meant in addition to what I
No, anything at all that you would like to add? In other words, any additional argument, case law, anything that you would like to add, you may do so now.
Okay, thank you very much.
Sure.
I do want to, I'm sure the court has seen the defense exhibit. They filed a timeline of the history of this motion, which was originally filed back in January of 2021. The motion was originally for the admissibility of hand-etched swastikas on the defendant's boot that he was arrested with after fleeing the scene, and also on the recovered on the AR-15 magazine. The motion has since evolved and now includes hate speech that was discovered and contained in the defendant's social media. When the original motion was filed, obviously the defendant had not pled yet, and the basis for that motion for the state's purposes was identity. Once the defendant pled in October of 21, that issue obviously was evaporated, identity no longer an issue. However, the state maintained the filing and wanted the court to rule on it in the future if it became relevant to the state in the penalty proceeding. And that would obviously be dictated by whatever the defense mitigation was during their presentation. So we've now reached that point where the defense has put on their mitigation, we're ready for rebuttal. It is at this point that the state would argue the motion is right. The defense has been complaining that the state did bring up the motion and they didn't get a ruling, so they couldn't question during jury selection issues about hate speech or swastikas. They had no problem asking about anal abuse. They had no problem asking about white privilege. They knew what records that they were going to be admitting. We did not. They admitted records from the school board, which is Defense Exhibit 92, and records were introduced in Carrie Yard, and that is Defense Exhibit 78. Both of those documents contain language about the backpack that this defendant wore with the swastika drawn on it, and also the phrase F N-words. Again, we didn't know who was being called or what evidence was being admitted, as this court saw maybe the night before, sometimes the morning of. So the defense knew what records they were admitting. They made the strategic decision not to question the jury about swastikas or hate speech. They cannot now come to this court and complain or blame the state when they were in control of the evidence that they were going to admit. They had the opportunity to pick and choose their evidence the same way they had an opportunity to pick and choose what to talk to the jury about. So now, based on the fact that those records are in evidence and that documentation regarding the swastika and the racial slurs there, any prejudice has now evaporated, and it's in evidence. And there were plenty of records. They didn't have to admit those records. They could have chose bits and pieces, but they didn't. They put them in evidence. They've opened the door, and now the state is going to march through. The photo of the backpack is what the state is seeking to admit. It is a photo of the defendant wearing the backpack, and you can clearly see the language that's written on it and the swastika that's drawn on it. It is to admit in the state's case of rebuttal to show he's not a victim of bullying, that anyone who walks around with that kind of language and symbols on a backpack is clearly provoking, and which also lends itself to the diagnosis of the state's experts, which is antisocial personality disorder. And since the state plans on putting on testimony regarding that, and that is also to rebut the defense experts' diagnosis of neurodevelopmental disorder related to prenatal alcohol exposure, along with alcohol-related neurodevelopment disorder by the defense. I'm sure this court recalls Dr. Brandon's lengthy testimony on July 7th, and he testified that social media searched by this defendant that covers racism, animal abuse, hatred towards women, Hitler, porn, Black Lives Matter, is all important to this diagnosis because it is a window into the defendant's mindset and hatred towards others, which is a critical piece in making that diagnosis. And for some reason, the defense keeps isolating words like Holocaust, Nazism, and Hitler, and argues because those terms don't lend themselves to any diagnostic criteria with antisocial personality disorder, they shouldn't commit. This is the totality of the search. The defense doesn't get to pick and choose what experts use in order to come to their diagnosis. This court heard that very, very long list of terms that Dr. Brandon read into the record. This wasn't the defendant doing research for a history project. This was clearly displaying his contempt for people, his hatred for people, his disregard for the rights of others, aggression, so on and so forth. All the checklists that goes towards diagnosing antisocial personality disorder. It's a multifaceted defense, and again, the defense doesn't get to dictate what social media the state's experts can and cannot use to make their diagnosis. They are not the psychologists, they are not the psychiatrists, they are not the experts. So again, the defense has opened the door by admitting the records, the documentation of the swastika and the racial slurs, and then for that reason, they cannot now claim prejudice. The state should now be permitted to admit the photograph of the defendant wearing the backpack with those items on it, the boot that he wore, photographs of the boot he wore on the day of the shooting, and the etched swastika that's on the AR-15. The state has as for social media, obviously the state has a right to rebut any defense mitigation. Both defense experts testified as to the diagnosis of MD-PAD and the ARND. The state's rebuttal is that the defendant should be diagnosed with antisocial personality disorder. That hate speech contained in the searches by this defendant is relevant and certainly part of the expert's overall diagnosis. So, Your Honor, for those reasons, everything that's in the state's motion 222, we incorporate all the other arguments that this court has heard, and I know it's very familiar. We would ask that we grant the state's motion for admission of all those items. Thank you.
Defense?
Good afternoon, Your Honor. The defense has had opportunity to review the state's motion at sub 222. Your Honor, and it's our position that the defense has not in fact opened any door. On September 1st of 2022, the defense called witness Carrie on. There was some documentation that she had maintained control and possession of since Mr. Cruz was no longer a student at the school for fear that the school board would have destroyed it, so she kept it. She turned that over to the defense during her deposition, and we wanted that documentation to be admitted during her testimony. We spoke with the state and asked that the swastikas be redacted from that document. They were in disagreement with that, and we had arguments as to that. We asked the court to redact the swastikas in light of the fact that we had not received a pretrial ruling on SF 202. I then went through the procedural history of that motion. I don't want to do that again, so I'm asking if the court will accept the arguments and the timeline that I provided on September 1st of 2022. Over the objection of the defense, the court allowed the state, indicated that the defense would have to submit all of the documentation with all of the information, specifically the swastikas that we asked to be redacted. So it was admitted. It was admitted after we had requested that that information be redacted, and without the court giving the defense the benefit of a pretrial ruling like we had requested before the jury was seated, before general voir dire was taken. Briefly, Judge, even if the court is going to continue to expand the ruling that you made on September 1st of 2022, this court still has the discretion to admit evidence and to limit evidence, especially if it's prejudicial, overly prejudicial, or cumulative. This is a thinly veiled attempt by the state of Florida to introduce bad character evidence. They want to get up there and say, did you see this social media post? Did you see this? Did you say that? Dr. Brandon testified that this information was necessary because, meaning the social media, because it showed a persuasive pattern of disregard for the rights of human beings. What the state did not elicit from that witness was that Mr. Cruz had done 8,700 searches, and only 430 of them contain the content that the state is seeking to admit. So it's not a persuasive pattern. Perhaps that's an argument that we need to make on cross-examination, that the court does need to take into consideration, since you, in essence, have already granted SF 202 on September 1st over the objection of the defense, that information can be cumulative and it can be overly prejudicial, and the state will be trying to make this a feature of the trial. Had the court ruled on this motion prior to jury selection, we would have voir dire on those particular issues. So in light of the fact that the defense was unable to voir dire on those issues, despite numerous requests to have the court rule on the state's pretrial motion, and it also would have impacted the presentation of our mitigation in this phase. The court, that we would also say that if the court is inclined to allow the state to get into this material, a door which we did not open, the door was opened by the court by allowing this carry-on documentation in over the defense of the objection, over the defensive objection of the defense. The court still has discretion to fashion an equitable remedy and to limit the amount of this information that is moved into evidence. If the court is inclined to grant the state's motion, SF 222, based on the fact that the defense did not have an opportunity to voir dire on these specific issues because the court had not ruled, we would also be moving for a mistrial. And I would just adopt all previous arguments, Your Honor, that related to this particular issue, specifically what was argued on September 1st, 2022.
I'm sorry, I missed the last part. You're moving for a mistrial for what?
Well, if the court is going to be inclined to grant SF 222, which is the state's motion to allow in the swastika, the hate speech, all of that information, this is a similar motion that the state had filed before Mr. Cruz had pled, and then had renewed it after Mr. Cruz had pled, and the defense had requested numerous times for a ruling on this motion so that we could fashion our voir dire and how we would anticipate presenting our mitigation. It would be impacted by this court's ruling. So if the court is inclined to grant this motion over the defense objection, we would be, again, like we did on September 1st, 2022, we're requesting this court grant a mistrial because the defense has directly been prejudiced by its inability, because of the court's failure to rule on this motion, to voir dire the jury members on these particular issues.
So, I'm sorry, I just make a quick distinction.
Sure.
Ms. McNeil is referencing records that were removed in by Ms. Young, which is the Defense Exhibit 78. They did not reference Defense Exhibit 92, which is from the school board, which has clearly written in there on threat assessment about the backpack. So that door has been open.
But state, just so that I'm clear, the additional arguments you're making, in other words, you're not substituting these arguments for the arguments previously made that these things, I'll call them things, like the swastika and the language and the searches and those things, your previous argument were that those things are probative of the diagnosis of antisocial personality disorder. You're merely substituting your argument saying, or not substituting, but supplementing your argument now saying, not only are those things true, but also the defense opened the door and that these items were contained within evidence that was put forth by the defense in their case.
That's correct.
You're not substituting an argument, you're supplementing.
Adding to.
And that evidence that the sought to admit was the documentation from Carry On. We had requested that the court redact the prejudicial information that was contained within those documents, and the court denied that request. So the court essentially allowed that information in evidence, so the defense was in a position where they either hide evidence from the jury or we give them a complete picture. We had no other choice because we need to be honest with this jury so that they have all the information they need in order to make a decision. The remainder of the school board records were in fact admitted.
Okay, first of all, I didn't keep anything out of the school board records. I specifically asked you all what you wanted out of the school board records, and you didn't know. The state was the one that had to tell you that those prejudicial items were within the school board records. So how could I possibly know what was in them if you all didn't even know it was in them? And you were going to take the time to try to go through it at a later time, and you wanted me to admit them with the caveat that you'd be able to go through and figure out which items you thought were prejudicial, and then you never brought it up again. So I don't know how you could be blaming that on me when I don't know what was in them. You had 5 boxes of records. When I asked you all what portions of those records you wanted out, you didn't know.
So Judge, after the court had ruled on the documentation, the composite for Carry On, which allowed in the swastikas, the defense was in a position to make a decision about whether or not we should move in all of the evidence because we didn't want the jury to believe that we had misled them. So when the court allowed the swastikas to be admitted in through Carry On over the objection of the defense and denying our request to have that particular information redacted, we made the decision that we had to admit everything because of the position that we had been placed in. And the court still is required to make a 403 analysis on the additional information that the state intends to seek admission of. So we would ask that the court exercise your discretion and apply that 403 balancing test.
Judge, I just point out that this was a strategic decision by the defense to admit all of those records. Nobody made them, the court didn't make them, they decided to put them all in, they opened the door, and now the state can go through it.
I'm going to have a written order by tomorrow.
Judge, if there's any way, if the court is in contemplation of granting the state's motion, that they could specifically allow us or advise the court as to what they tend to admit so the court can make a determination if you in fact do need to limit the amount of it so that it's not cumulative or overly prejudicial.
I don't know what you're asking. You want me to order the state to tell you in advance what they're going to put in the rebuttal case?
No, specifically the items that they refer to in their 222. Is that the court is going to exercise your discretion to try and limit the amount of that information so that it's not cumulative, so that it's not overly prejudicial. The court doesn't have any way or ability to make that determination, so we would ask that the state advise the court and the defense what information they intend to introduce that supports what they have in SF 222.
Okay, well, their wherefore clause on page 5 sets forth exactly, and I'm assuming that you're not asking to put any more or any less than what's indicated in your motion, which says firearm magazine hand etched with swastikas on each side of the magazine, loaded in the AR-15 firearm used in the shooting and left at the scene. 2, the boots worn by the defendant when he was arrested approximately 1 hour and 20 minutes after the shooting began, which has a hand-etched swastika on the right boot. 3, the photograph of the defendant's red backpack depicting a swastika and racial slur. And 4, hate speech contained in the defendant's social media.
So thanks for the clarification on that, Judge. I think that my argument needs to be more specific as to number 4, which is the hate speech contained within the defendant's social media. There's over 400 potential searches that the state could be relying on, so we would just ask that the court seek some direction from the state so that you can exercise your discretion to make a determination if it's going to be cumulative, overly prejudicial. The court has the ability to limit evidence. It's within your discretion to do that. Thank you.
Do you have any idea of whether you intend to use all, some, or? Sure. And you can let me know at a later time also. Yes.
We will provide a list at this time. I would tell the court it's not to be a feature of the trial, but as far as there's a timeline progression, and, we want to make sure, people, what is relevant and, it's relevant to whoever's testifying, so we provide it to the court, to the defense, but I can't do it right now,
Okay, when can you have that prepared?
in the next couple of days.
Okay. Now, as far as these other two motions are concerned, obviously I would like to hear them before next week.
Judge, we would ask if we can come back tomorrow because the court's ruling on DMIL 16, if the court is inclined to limit the state to certain experts, then, otherwise we'll be preparing motions in limine on experts that may never be testifying and would be asking for additional hearing time to hear those motions in limine. So it's sort of in other words, it's like one depends on the other. It's a progression. So once we know the court's ruling on DMIL 16, then we'll know which of these experts we need to file motions in limine regarding.
State, I don't mean to put you on the spot, but if I give you like 30 minutes to look this over, can we do it this afternoon, or do you need do you need to reset it? I am putting you on the spot. It's not my intention, but
It's 3 o'clock. Okay, girl.
sure, today? I mean, I assumed we were gonna be here all afternoon, so that's fine with me. I appreciate that, and if there's anything else, you all can get together before 3 o'clock. We'll recess till 3, and then we'll come back and I'll hear these, okay? All right, thank you.